Right, good morning everybody. I can confirm that this meeting has been properly called and we are quorate. Can I first ask members to appoint a chairman for the meeting, please? Councillor Dempster, are you willing to accept your nomination? Thank you.
Good morning, ladies and gentlemen. And firstly, can I apologise for the short delay. There was some misunderstanding amongst members of the actual time of the LRB, and I was one of the culprits, so my apologies for that. Welcome to this meeting of the local review body, the 2nd of December 2016. Confirm that the meeting has been properly called and is quorate. That Claire's already said that. Can I have Sederunt and Apologies, please, Claire?
Thank you, Chairman. Move apologies from Archie Drybrough today.
Thank you. And can you just confirm that there is a one notice review for consideration this morning?
Yes, we've also got declarations of interest, Chair.
Oh, of course we have. Do any member have any declarations of interest on this item? Okay, thanks for that. In that case, we now come to item 4, Low Killiemore, Kirkcowan, Newton Stewart, refusal of planning permission for removal of condition 2 of planning permission previously granted under 90 TP/1/0410, restrictive occupancy condition 15/B/1/0318. Can you just now confirm what the process is, Claire, please?
Thank you, Chairman. I'll happily take the members through the papers and then explain what the options are to the local review body, and then the LRB would review the case. So,
Thank you.
as you stated, you have the case up for today is item 4, and you have a number of documents in your papers, being the notice of review and related documents, report and handling, related correspondence, observations of the appointed officer, comments of the applicant's agent, the original planning application form, decision notice, the relevant extracts from the local development plan, photos of the applicant's site, and the grounds of refusal in this case are on page 144, being that the removal of the occupancy restriction in condition 2 of planning permission 90P10410 would be in direct conflict with and undermine the agricultural need policy justification on the basis of which planning permission was originally granted for the dwelling house. As such, the proposed removal of this condition would be contrary to the provisions of the local development plan as stated in the Dumfries and Galloway Local Development Plan Policy H3, and to adopt a supplementary guidance on housing in the countryside. The requested method of determination in this case is on page 10, being that the applicant has requested that the review be dealt with by a review of information provided and also by means of inspection of the land to which the review relates. The applicant considers that a site visit is essential for the local review body to appreciate the limited nature of the agricultural unit and the restrictions of access. You have the grounds stated in the notice of review on pages 13 to 23, which are in summary: the loss of condition 2 of planning permission would not be contrary to the aims of the SPP or Local Development Plan Policy H3. Removal of this condition would comply with the guidance at paragraph 102 of Circular 42998. You also have the circumstances of material change since 1990, when planning permission was originally granted, and the workable agricultural land at Low Killiemore is only 9.62 HA 23.78 acres in area which is insufficient to support an agricultural enterprise. The dwelling cannot therefore be occupied by an agricultural worker employed full-time on Low Killiemore. If the further comments of interested parties, being the comments of the appointed officer, comments of the applicant's agent on the observations of the appointed officer, you have the development plan policies, being Dumfries and Galloway Local Development Plan, H3 in the countryside, the LDP supplementary guidance, housing in the countryside, and with your other material considerations being the SPP and the circular for 1998. So the main issues that the local review body may wish to consider are whether or not members wish the description of the proposal to be amended from what is in the associated papers to what is put forward by the applicant's agent at 1.1, page 16, and commented by the appointed officer at 2.1, page 113 to 114. And you have, should the local development plan policy H3 be used in assessing the case? What weight should be given to the guidance provided by the Scottish Planning Policy and Circular 32012 when weighed against the terms of the development plan? Does the condition meet the guidance set out in Circular 4/1998 as circumstances prevail at the site, and in particular, is the condition necessary? Would the development be consistent with the terms of the development plan without the condition? Have circumstances materially changed since the original application, such as the agricultural need which justified the approval of the house in the first instance, no longer exists? So, having outlined the documents within the members' papers, it now falls to LRB firstly to determine whether it has sufficient information to consider the review. It's confirmed that there will be no representations from any party heard today. The local review body has a number of options. It can decide it has sufficient information to determine the review today. It can request further information in the form of written representations. In doing this, LRB would be required to state precisely what information it was seeking and who would provide it. It can resolve to hold a hearing, again specifying who would be invited to speak and on what matters. And it can resolve to hold a site visit, accompanied or unaccompanied, and this can be done in conjunction with any of the above, but would not allow a decision to be made today. So if the local review body resolves it has sufficient information and that no further procedure is required, then the local review body has the full powers to uphold, reverse, or vary a determination. The decision notice will include a statement of the terms in which the planning authority has decided the case reviewed. You have an independent planning advisor present at your meeting. It's confirmed he has not had any involvement in the case and was not the case officer or the appointed officer for the application. He is here purely to provide independent advice as needed on matters of planning policy, law or process of the local review body. So if members are clear and no further clarification is required, I will ask the chairman now to lead the debate and in the first instance to lead the local review body through the agenda papers together to decide if it has sufficient information before it can make a determination today.
Thanks very much, Claire. I should have said at the outset as well that this meeting will be recorded and made available for public listening, should anyone wish to access that. Okay, thanks members. I note that there is a request for a site visit and we can determine to hold that site visit at any time. That decision is not necessarily required at the outset. However, are members satisfied they have enough information to determine this matter today? Councillor McKay? Tracy, can you provide Councillor McKee with a spare card, please, so that his statement can be recorded? Yeah, we'll do that. Okay, that's fine. We'll go through the papers, item by item. Okay, members, we firstly have the notice of review and related documents, pages 5 to 104. No comment on that. We have the report on handling and related correspondence, pages 105 to 110. Any comments or questions on that? Observations of the appointed officer on the applicant's agent's notice of review, pages 111 to 116. Are there any questions or observations on that? Stephen?
Yeah, I mean, I don't have any comments as such in terms of information that I don't feel is missing, if you like. But obviously there'll be questions maybe that arise when we go through the actual review process. So, so I'll just add that, I suppose. I don't have any concerns that I'm missing information so far.
That's fine, Stephen. I think we're just confirming at this stage that we've got all the different sections, and then we can go back to questions after that. Comments on applicant's agent or observations of the appointed officer, pages 117 to 120. We've got that. Planning application form, plans and supporting documents, pages 121 to 139. Do we have that? Decision notice from Dumfries and Galloway Council, pages 141 to 145. Relevant extracts from the Dumfries and Galloway Local Development Plan, pages 147 to 162. Photos of application site and the locality, pages 163 to 166. And we have the grounds of refusal, page 144. Robert, did you want to come in at that stage?
Chair, it was just to offer the option of the visual presentation on the screen, which replicates the photographs that you have on the pages in the committee papers, if that's helpful to the local review body today. Quite happy to present that.
I think that would be helpful at a later stage. Remember, do you want to see them now, Jane, or at a later stage? Now, okay, Robert, can you do that now, please?
Certainly. First picture I've got, these pictures have been provided by the appointed officer for the case. I haven't been out and I haven't undertaken a site visit because I'm the independent planning advisor in relation to this matter. This is an aerial view. It shows the house and the land holding itself. So you've got the house outlined in red. The land holding itself, looking at the plans that have been submitted, now these appear on page 137, the location plan with the application. What's quite useful is the location plan and the aerial photograph on page 139, because that also shows the overall land holding of 15.85 hectares as it stands now, and it gives you an idea of the various land holdings, the land parcels rather, that make it up. So your blue area there is accounting for that 15.85 hectares, and it shows you where the house is in relation to that. Moving to the house itself, this is the view of it as you proceed along the track going past it. You can see the kind of driveway, if you like, on the right hand side. Quite a large detached house. And you've got another view. This is further towards the B733 as you approach along the access track.
I think that's been helpful. It's much better than the images contained in the papers. Okay, that concludes the sequence of matters that are incorporated in our papers today. The members now want to go back and go through these sections one at a time. So we have a notice of review and related documents, pages 5 to 104. Members will have noted that, and I think that's where the request for the site visit was contained. You happy with the papers that are before you, and do you have any questions on that? Stephen?
Yeah, I mean, I'm sort of being guided by what we're looking at in terms of the main issues for how we consider this. So I suppose, I mean, I would probably find it helpful if we maybe discussed whether or not the proposal, as it were, that's to be amended, if we maybe, yeah, tease that out of the papers in front of us. I mean, that's just a kind of view, but rather than go through each sort of submission line by line, as it were, really we're here to determine if, you know, if we're sort of, if the, for example, local policy H3 is the appropriate policy to measure this against, for example, or and maybe we should address it like that, but I'm happy to be guided by the rest of the the body, Chair.
Okay, Stephen, so on the little fact sheet you have in front of you, page 3, we have main issues. Are you suggesting that we simply go through the main issues and deal with that rather than the whole document that we've been given? Because obviously we've all read each and every page contained within that. We've studied it closely, so I'm more than content to do that in the manner you've suggested. So if all members are happy with that, the first issue is whether or not members wish the description of the proposal to be amended from that in the associated papers to that put forward by the applicant's agent at 1.1 page 16 and commented upon by the appointed officer at 2.1 pages 113 to 114. And I'm in members' hands now. Sir McKay.
Could I ask a question on the width of this bridge? Have you got a measurement for the width of the bridge? So there's comment made where the bridge is not wide enough to take agricultural traffic and that, but looking at the picture, there's some quite big vehicles can get across there. I would have thought lorries and vans and things like that. So with a measurement, it maybe help.
Robert, do you have that detail?
Don't think I've got that detail to hand. I can have a look through the papers and see if I can find it anywhere within that. And if so, I'll certainly let the members know. But off the top of my head, I don't know how wide that bridge is, no.
And reading the paper, I didn't see any indication of the width at all. Just the comments for the agent is that it's only wide enough for a small car, but looking at the photograph, I wouldn't have thought. I would have thought it was wider than that.
Thanks, Jock. I think on the question you posed, there are two issues: whether or no a site visit would help, and whether or no it's relevant to whether because obviously it has served the unit to date. So whether or not that's material enough for you to have a question, we'll leave that, see if Robert can find any additional information for you.
We've got no indication.
In fact, there was a comment from the agent, and that looking at the bridge from the photograph, I would have thought it was wide enough for normal, if you like, traffic.
I think the point is that a site visit would determine that, a delay would determine that, and then the other point is whether or no that would be of significant importance to persuade you to either have a site visit or change the decision the officer made. Jane?
Well, I would ask whether or not the bridge has changed. There's no indication in the papers there's been any change of the bridge, and we have to have a material change. So it's not here in front of us that that's changed, and so I would suggest from the point of the original application to now, there is no suggestion that that has been a change, and it would have been put in had it been a material change. So I suggest that I'm perfectly happy with what's there.
Thanks for that, Jane. Councillor McKay?
I'm quite happy with that, Chair. That's the kind of view I took as well. It's operated since 1990 or 91 up till now, so it can't be that bad.
Okay. So are members content that they do not wish the proposal to be amended from that in the associated papers? Jane?
Well, I would like to actually get our advisor to help us tease this out about the procedural matter. I'm slightly confused about it, and maybe somebody could give me some help on it. Seems to be, it depends, the wording is without compliance with condition 2 or the removal of condition 2. And if we go on, the planning officer actually suggests that the application would better have been described as erection of a dwelling house without compliance with condition 2. But I would like to have explained to me exactly what the implications of that are. I'm not totally clear that it's absolutely relevant.
Thanks, Jane. Without leading members, Robert, can you explain exactly what the situation is, please?
Certainly, Chair. I mean, the issue arises within the applicant's agent's statement. So that's on page 16 of the papers at 1.1. And it's the way the application's been described So when you see in the decision notice the description of development is, as they put it, application for planning permission to carry out the development without compliance with condition 2 imposed in the grant of planning permission 90 TP 1410. They are suggesting that is what it should be rather than what it appears as it appears in the decision notice. So it's a section 42 application under the Act, so it's seeking to vary or discharge the terms of a planning condition attached to that. So what they're saying is it should be more properly described as a development without compliance with a particular condition, or without it completely seeking to remove it. Turning to the appointed officer's comments, at the foot of page 113, and looking at the top of page 114, the appointed officer does say it would have been better described as erection of dwelling house without compliance with condition 2 of planning permission reference 90 P1410. So I don't think there's any real resistance to a change in the description of the application, if it helps clarify the nature of what it is that's being looked at. Essentially what's sought here is the removal of planning condition 2 as it's worded from that planning permission. So you've got an unfettered dwelling house, it doesn't restrict the occupancy, you don't have that restriction anymore. If the application is successful and you're minded to grant permission, you're removing the condition. You're not quashing the previous permission, you're issuing a new permission which doesn't have that condition on it effectively.
Is that helpful, Jane? Stephen?
I mean, what struck me as I was trying to understand this was the notion of development and erection of dwelling house, but clearly the reality is there is a dwelling house there, and that's for the senses to perceive, as it were. Given the sort of the nature of this particular, given the timing of the original application and the conditions attached there and what's been asked for now, the fact that there's already a development and we're looking primarily at the condition, I suppose I'm sort of trying to think what's the safest way for us to consider this in terms of if it's considered as a new application or de novo, if it were to be refused, what happens to the dwelling house that's already there? I'm sort of trying to follow through the scenarios. Does that mean, well, that should be removed, or the resident should be expelled, or, in layman's terms, it doesn't seem to, I don't know what the safest way would be to deny the existence of a house that's already there.
I think that's fairly well laid out in the papers and the officer's response at the end, but Robert, can you just help Stephen with that?
Yes, certainly. I mean, my understanding with Section 42 planning applications is it's a freestanding planning application in its own right. So you will make that, and it does cover the variation or discharge of a condition from a previous planning permission. It isn't a variation to the previous planning permission, so it always exists as a fallback, if you like. So it's always going to be there. The question is therefore how you deal with this application that's in front of you. You can either approve this or you can refuse it. That's obviously the focus of today's meeting. If you're minded to refuse the application and not vary the terms of that condition, you're simply not issuing a new freestanding planning permission for the dwelling house without compliance with that condition. If you are minded to effectively remove condition 2, or issue the permission without that, you would issue the same terms and conditions as previous planning permission, except without that occupancy condition attached to it. So you're issuing a fresh planning permission.
Stephen, do you want to come back?
And I take it that's where we then look at, well, if that was the route that we chose to look at, would then that be appropriately considered under H3 as is described in the papers?
Robert?
I think as with any application, it's got to be considered at that point in time against terms of the development plan, relevant development plan policies and other material considerations, and obviously the weight you give to each relevant factor, the balance, if you like, is a matter for the local review body. In this case, it's not clear-cut how you weigh that at all. There's a lot of planning history to this one. You've got a history of an application that was granted in 1990 in a very different policy context. You've also got Scottish Government guidance that is saying different things as well relative to this, and you've got a set of circumstances that has changed over the years at the site. So I would suggest, yes, local development plan policy H3 is relevant in this case, but you're looking at a decision where material considerations are very much to the fore. So you might want to make a decision, for example, that is looking at the development plan, but where you're maybe giving quite a lot of weight to other material considerations in your decision.
Thanks for that, Robert. Councillor McKee?
It's just the relevance of some of these papers, Chair. Page 46, it's a planning appeal reference. Something to do with Carla Cottage, Stain Bent Farm, Stains Shots. Another one's referring to dwelling house and garage at Kirkcowan. Has there been a change of name to this application over the years, or to this house and site over the years?
I think the first thing is information that the applicant has, or the agent has provided you, so that you can consider it in light of where other decisions have been made with other local authorities. But can you just maybe explain that better, Robert, please?
Yeah, my understanding of the appeal decision, without being able to find the exact phrasing in the notice of review, is that's been submitted because they feel that is an example of an appeal case that is particularly relevant to this case and should therefore carry a lot of weight in your consideration. You know, it's a different address, yes, this appeal decision, that's correct, but they feel that the circumstances of this case are similar to the one that's under examination today, and they feel on that basis you should give it attention and some weight in the process.
Joe?
Thanks for that, but they also admit in the papers that each case is decided on its merits, so it's how much weight we give to these papers. That's a decision we have to make ourselves, I take it. Thank you.
No, you're absolutely right in respect to that, Joe. If there are no other members, then on the description proposal, we go to, should local development plan policy H3 be used in assessing this case? Members have to decide whether or no it should be used. You have advice from the officer, who's not the case officer, that it is relevant. Are you prepared to consider it as relevant in this case?
I would certainly agree with that, Chair. The relevance is still there.
Okay, if there are no alternative view, the board have agreed to consider H3 and that it be used in assessing this case. The next question is what weight should be given to the guidance provided in Scottish planning policy and Circular 3/2012 when weighted against the terms of the development plan. Do you want some advice from the planning officer in respect to that statement? Robert, can you just maybe explain in layman terms what that actually means? Point 3.
It's really, I mean, the bullet points are looking at the case that's been put to you on behalf of the applicant. So, for example, when we were looking at the development plan and policy H3, that was in reference to the issues raised in the applicant's statement of review, if you want to call it that, at 4.1 and 4.2. So that appears in the paper. It hasn't reproduced too well, but it's in page 19. So then the applicant's agent then looks at material considerations that are considered to be relevant. So there is a part there about SPP and what paragraphs 81 and 83 of SPP say. So that's at 5.1 and 5.2. And then it looks at Circular 3 of 2012 does incorporate, slightly bizarre, but it does incorporate advice from the Chief Planner. There was a letter did the rounds back in November 2011 about occupancy conditions and trying not to unduly tie them to agricultural properties where it wasn't necessary, and that's now been incorporated into Circular 3/2012. So you need to look at these factors and take these into account as material considerations in your decision, but how much weight, as has been pointed out, how much weight you give to the relevant factors is a matter for yourselves as a decision-making body. The question is, obviously for yourselves, how much weight do you want to give to the guidance in the SPP and Circular 3/2012? The other consideration you'll see in that submission is Circular 4 of 1998, which is guidance on the use of conditions and planning permissions, which is obviously key in this case as well. There are various tests and pieces of guidance set out within that document, and although it's quite an old piece of guidance, if you like, that the principles set out are still as relevant now as they were back then.
Thanks, Robert. I think you just dealt with bullet point 4. We're just dealing with bullet point, unless they're tied together. Bullet point 4, does the condition meet the guidance set out in Circular 4, 1998 as circumstances prevail at the site, in particular, is the condition necessary? So that's another consideration you'll have to make, and you've already been given advice by the planning officer in respect to that. And lastly, would the development be consistent with the terms of the development plan without the condition? Have circumstances materially changed since the original application such that the agricultural need which justified the approval of the house in the first instance no longer exists? I can maybe touch on that as well, Robert, please, just to give members clarity what exactly is we're being invited to consider here.
The final bullet point, I mean, clearly you're looking to entertain an application. The dwelling house is in existence. You can see that it relies on an old planning permission from 1990. What you've been asked to do here is consider that dwelling house, should it be granted permission without that occupancy condition. So you need to consider, in your view, is that consistent with the terms of the development plan without that condition, in addition to your own thoughts about the condition in terms of shaping up with Circular 4 of 1998. Have circumstances materially changed since the original application? Well, they clearly have, but have they changed such that the agricultural need which justified the approval of the house in the first instance no longer exists? So are you looking at a scenario where you don't feel the occupancy condition is necessary or reasonable or required in this case? If you're looking at a departure from H3, is there a reasoning for that? Or do you feel that there hasn't been sufficient justification to set aside the terms of the occupancy condition? It is, I mean, the other thing to take into account in all of this, of course, is you've got further comments from the appointed officer within the papers, and they're in pages 113 to 116, and in response to that, you do have further comments from the applicant's agent, and they appear on pages 119 to 120. But in essence, these are the kind of issues you need to think around. And if you do take the view that it is a departure from the terms of the development plan, are there reasons to justify that approach in the circumstances of this case, in your view? But it's just to kind of acknowledge these types of things and think around these types of issues at this stage.
Thanks, Robert. Stephen?
Thanks, Chair. Yeah, I mean, I've got a degree of sympathy with on page 119, where there's in section 3, there's the last sentence: the policy H3 nor the supplementary guidance are effectively not relevant, should not be applied in this case. And I think, I mean, on the surface, there is a house in the countryside, so we're almost like being invited to consider it under H3 because that's housing in the countryside. But I don't know if we're almost being, if there's a temptation to try and fit something into a policy that's not quite really what it should be considered under, or the only thing that should be considered under. And I know you're touching on that in terms of these are some of the issues we need to look at in terms of there's been a material change, clearly, in terms of the original application and condition. It was associated with over 100 hectares of land. This has obviously been broken up as time has gone on. You're now looking at a situation where there's a completely different, if we were to consider this as a new application where there was no house on a piece of land, then yes, H3 would be totally relevant. However, we're almost left with a kind of H3 hangover, which is here's a house already here, the situation that achieved the original permission has changed. How can we meaningfully consider this under H3, given that it doesn't quite fit in the same way? It's like a legacy decision. So I'm not sure quite where it would fit. So clearly there must be a reasonable path through this, but I don't know if we should consider it by exception to H3. There's a case to be made in terms of a material reason for removing the condition, for example, but it still wouldn't sit nicely with H3. So I would be wary about trying to fit it into something just to keep the policy happy, when really we've got a reality here which doesn't quite sit easily anywhere. So I think that's kind of where my mind is at the moment, which is clearly a confused place. But
I think when we come to that, because we're just quietly going through the process and we'll have to deliberate, and these kind of points will be debated further along the process. Robert, did you want to come back to some of that?
There was only one point I was going to make, and that was you've got to really treat the Section 42 application you have in front of you as a separate planning application. You're not redetermining the original case. The original planning permission still exists as a fallback permission, regardless of what happens today. And the applicant always has the benefit of that permission, so they have the benefit of the permission for the house with the occupancy condition. So I don't think on that basis you can then look at the principle of developing a house at this particular location. That's not in jeopardy in this case, because there is that fallback position. The only real thing under consideration here is, should you impose the occupancy condition or not? So I think that should be the focus of consideration, rather than the whole entire principle and form of the development that's here. That would make sense, given you know the applicant's got the fallback position of a permission, and that's been there for 26 years.
That's helpful, Robert. Okay, members, having outlined the documents within members' papers, it now falls to the LRB to determine whether it has sufficient information. Oh, sorry.
An issue on page 115, 2.2.5, it indicates that there's more to agricultural in this than just cows and sheep, and this land could be used in different ways. And also that the applicant, when he bought the house, purchased the house, he knew the conditions attached to that house and the land holding that he had. And really to change the conditions now, because maybe doesn't suit, or it might not suit in the future, I think would be wrong. And I think that the 2.2.5, as far as I'm concerned, covers the agricultural use. As it says in there, that covers a multitude of things, not just keeping animals. And I think that's the way we've got to look at it.
I think we'll come to that, David. We're just quietly going through the process, because clearly Stephen is airing a degree of sympathy and you're airing a view, and we'll definitely have to get to that. But it's just a couple of things we need to deal with before we go there. Having outlined the documents within members' papers, now falls to the RAB to determine whether there's sufficient information to consider the review. It is confirmed that no representations from any party will be held today. So that's the position we're in. Have you sufficient information, members, to consider the review today? You have options. The options available to the local review body for this case today is that it can decide it's sufficient information before it to enable it to determine the review today. It can request further information in the form of written representations. The LRB will be required to state precisely the information it's seeking and who must provide it. It can resolve to hold a hearing, again specifying who will be invited to speak and in what matters, or resolve to hold a site visit, accompanied or unaccompanied, and this can be done in conjunction with any of the above, but would obviously not allow a decision to be made today. The local review body resolves that it's sufficient information and that no further procedure is required, then the local review body has the full powers to uphold, reverse or vary a determination. The decision notice will include a statement of the terms in which the planning authority has decided the case reviewed. So at this stage, members, before we go into debate, have we sufficient information before us, or are there other requests for further information or a site visit to be made by any member of the LRB? Jane?
I think that we've got sufficient information in front of us. I think there's sufficient information in these papers for us to take a decision today. I think the real issue is the reduction in the land that is available. Initially, what was put with the occupancy was much larger, and the big issue is the reduction in the amount of land. Now, which way you go on that is not determined yet, but I think that's the main issue, and that's the specific fact. It's in here. I think there's enough information.
Okay, thanks, Jane. You are aware that a request was made for a site visit, but you're happy you have enough information today. Any other member otherwise minded? Joe? No?
Quite happy to go with Councillor Maitland's recommendation.
Okay, then it's been unanimously decided we have enough information before us to make a determination today. We now come then to the debate, members, and how we deal with the request for removal of condition 2. Stephen?
Yeah, I mean, I think this really sits on, I suppose, how well we measure whether the condition is necessary or relevant. And I think obviously we've touched on already the change in the material change in the land associated with the development. Are we able to? I mean, are we able to seek a wee bit further advice from the planning officer in terms of the how we measure the necessity of the condition?
Well, it's now up to the planning officer to guide you. There will be a formula that determines how or what comprises a person's requirement as an employee, and there are statistics that determine land use. But really, that's not relevant today because it's quite clear from the papers that the stock figure that's presented in the papers can be sustained within the land that's available. And the officer has quite rightly said there are other opportunities that could be explored that would still allow it to be a commercial and viable enterprise. So I don't think it's up to the planning officer to guide us, but I'll allow Robert to offer either an opinion or tell you that's not his place.
Chair, there's the test set out in Circular 4 of 1998 regarding conditions. And I'll try and find this. The applicant's agent has covered this. So, yes, it's on page 20, which is the applicant's agent's submission. It's at 5.3. So you've got the 6 tests. So any condition you should impose should be necessary, relevant to planning, relevant to the particular planning case, so the development to be permitted, enforceable, precise, and reasonable in all other respects. That's quite a long-established principle, and it's held with the courts and so on. What you're looking at, I mean, that's, in a case like this, it brings the condition's quite old, it dates back to 1990, obviously, in circumstances as it prevailed then. What you're forced to do today is look at the same condition and decide whether it still meets those tests, as far as I'm concerned. What you must first do then is look at the precise wording of the condition, and it's on page 17, so again in the applicant's agent's submission at 1.5, it says that the dwelling house hereby approved shall be occupied only by persons employed locally, full-time in agriculture, as defined in section 275 of the Town and Country Planning Scotland Act 1972, or in forestry or dependence of such persons. So that's the condition that's under scrutiny. What you've seen, what's been put to you is, obviously there's been a change in circumstances since that condition has been imposed. What you need to really try and satisfy yourself now is whether, in your view, you feel that condition meets the test, the 6 tests set out in Circular 4 1998. And if you think that the condition does meet those tests, then you should retain the condition, or you could amend the wording slightly. It's within your power to do that. Or alternatively, if you don't think that the condition meets with the test set out in that circular, then you should grant the application and you would issue a freestanding planning permission for the house without that occupancy condition attached. So that's the key test. It's really looking at the wording of that condition and trying to work out whether or not it meets the test set out in the circular. And you've obviously got a range of policies and guidance as well, both at council level and the LDP and at national level, which give various pieces of advice too, and they've been summarised in the paper as well.
And I'm right that if we decide to overturn the decision, we have to place on record reason for that.
That's correct. If you're minded to depart from the terms of the development plan, you need to give reasons for doing so. That's correct.
Okay. Stephen?
So just, I mean, while we're obviously still cogitating around this, given that there's somebody occupying the development at the moment, and should they no longer be employed in full-time agriculture as defined in that section 275, how do we enforce that? Do you boot them out, or how do you force somebody? You know, it's a practical question really. But if somebody is already there, for example, and no longer works full-time or part-time in agriculture or whatever, how would we normally go about enforcing that type of thing?
I think we're maybe straying from the point here, but Robert?
If you had a case like that and you felt it was expedient in the public interest, you would write to that person and make them aware of it be a breach of condition they would be in breach of, and you would need to obviously try and demonstrate why you felt they were in breach of that condition. The onus of proof would be in the planning authority to demonstrate why they were, and then you would take reasonable steps to see that condition complied with. So see someone else occupy it. I mean, the occupier at the same time would have the opportunity to make an application like this to vary or discharge the terms of the condition in question. I don't think it's not for me to say because it's not within my remit, but I don't think any planning authorities would go steaming in trying to serve a notice that would see people evicted and out the street in a matter of weeks or months.
Stephen?
So going back then to when we were looking at the test that conditions have to meet, you know, already your question, well, is that enforceable? You know, is it relevant? Is it reasonable? And I think we're, you know, just from the answer I've just been given, I'm thinking, well, it's probably not. I can't really think of examples where we would invest time and effort to the extent where it would seem to almost go beyond what's reasonable. But that's just, I'm still thinking around this, but in reality, that condition, should that situation be the case and somebody was in the house already and no longer working full time, I don't know how reasonable that would be as a condition given this current situation. But I'm just, you know, obviously I'm at the will of the other members and I'm just debating this at the moment.
There's a wonderful phrase called not in the public interest, and Robert already used it. But then even if that individual, he or she, was allowed to remain in the property for the remainder of their natural life, it then ensures that the policy still remains and that the house is still tied in the future for a foreseeable period of time. So it shouldn't be about whether or no, this decision shouldn't be about whether or no a person can be removed from a property, because what we're dealing with policy issues, no individual occupancy issues. And if you were to set a policy like that, you would find within a few months there would be no conditions in any property, because the same position would apply right across the region. So I think in the public interest would satisfy any occupancy issue that existed for someone who could no longer farm but couldn't sell a property on. But again, that's not for me. Robert, is that a fair assumption?
I think it is. In answer to the question, I think that condition is enforceable. The whole question of whether or not you pursue enforcement action, how you do that, you know, is it expedient in the public interest? You know, what form would that enforcement action take? How long a period of time would you give for compliance with all of these matters, or operational matters for the enforcement officer would need thought through, and there are reasonableness questions here as well. But yeah, it's obviously not something that's under consideration as part of the review today.
No, Stephen?
Yeah, no, I mean, it's helpful to me in terms of being able to consider this because it helps me separate out what's in public interest and what's actually reasonable under policy, if you like. So I know it sounds like a bit of a crazy question. One's, you know, an individual case. I'm not trying to set policy or change policy per se, but it does help separate out what's what potentially could be conflated, if you like.
Thanks for that, Stephen. Any other members? Jane?
Obviously, it's a difficult one because I think it's quite clear that the circumstances have changed from the original application. But if we go back to H3, I mean, we would not get, there would be an agricultural occupancy condition placed on this if we went back to where we were. I rely quite considerably, I think, on the comments of the appointed officer with respect to conventional agricultural activities. And it seems to me that I think it's perfectly reasonable to continue with an occupancy. It was there to start with. It was there, it's always been attached to the house. That was attached to the permission. And I don't really see particularly why there should be any change. It's been absolutely obvious what's been happening, whether it was right or wrong, and it's actually wrong in terms of our policies because we are seeking to provide sustainable agriculture, but it's been perfectly clear that sustainable, sustainable businesses and enterprises. But it seems to me that there is an attempt to remove an occupancy condition, which is a perfectly reasonable occupancy condition based on our policies for housing in the countryside, and it's been known that it's been being removed, but we can still expect people to carry out some form of agricultural activity from that property. So I must confess I'm not persuaded by the arguments of the applicant in this particular case. Happy to hear what other people have to say.
Stephen?
Yeah, thank you, Chair. I mean, I would say that I would say that I do think there is a material change that would justify removal of the condition, given that the original permission was based on a different hectareage of land, if you like. I'm aware that you could argue, I suppose, well, it's possible to develop some kind of modern agriculture technique or use of the land that may or may not make it sort of viable full-time business. But I think that the scale of the material change from what was originally granted to what it is now in terms of the area is a sufficient material reason to remove the condition.
Okay. Councillor McKee?
I think we've got to look at the house and land was purchased on the basis that it could maintain agricultural use. Now, the original application was for 90 beef cattle and 40 sheep. The Department of Agriculture and Fisheries for Scotland was consulted, and they said that was suitable for agriculture, and they supported the proposal. Now, this individual who bought this house and this piece of land, he bought it on the basis that he was quite happy to carry out a piece of agriculture. He was retiring, and this was his retirement job, if you like. And he bought the premises on the basis that he could do that. And I think nothing has changed in that respect. The same size of land's there. And I think we've just got to keep the conditions as they are at the present moment.
Thanks for that, Councillor McKee. Well, there've been a number of observations, some conflicting, I'd have to say. So, on the basis that we don't seem to be unanimous, are there any proposals on how we progress this matter? We've had an opportunity to debate it, express a view, and now we have to come to the kind of formal part. Jane?
Well, I'm wanting to be absolutely clear. I mean, what's difficult, I think, for me in a way, is that the suggestion that it's about removal. Our policies are silent on removal of this sort of thing. Actually, I mean, if there's one thing we've learned, I think that we ought to be a bit clearer about what we do, about when we do or don't remove this sort of thing. The difficulty that I'm finding is that the wording of, I think, the use of conditions in planning permissions goes on to say, unless it is shown that circumstances have materially changed, and this is the bit that I can see that is a bit wobbly, is that the agricultural need which justified the approval of the house in the first instance no longer exists. That bit there. Because if you reduced it to complete absurdity, you could get an occupancy. You could build your house in the countryside with your 100 hectares round it. You could say it needs 100 cattle. We'll go way up to whoever it is to suggest that you need that. Half an hour later, sell that property, and then come back and tell us, oh, it no longer exists. I mean, that's the absolute, eventually, the ridiculousness of it. If you took what was going on to its absurd level. So that's what I find quite difficult here, because it's the actual justification that is the 90 cattle. I mean, that clearly doesn't exist now. Nevertheless, if you describe that an agricultural need that existed, yeah, I see no reason why we should remove that. There is an agricultural need. That's what's attached to that house.
I take it that isn't quite a proposal, that's another observation. Stephen?
Yeah, I mean, if anything, that helps crystallise even more that I would move that we remove that condition, given that there's been such a material change in terms of the original attachment of the condition that it's no longer relevant nor reasonable. And I think in terms of H3, I think it's much easier going forward whenever we're considering housing in the countryside. For example, we would be looking at cases where that would be something that would be relevant today and maybe for a number of decades. But clearly, this is in effect applying H3, if you like, in some way to a legacy case, and you're always going to get that because the needs and use of the land does change at times over. And I think we need to have a way of at least being able to deal with that rather than maybe unnecessarily stick too closely to policies, sort of in a bid to protect them, if you like. But I think policies should be there to guide rather than enslave, as a number of members tend to say. But I think I would move to remove the condition.
Is that a formal proposal?
Yeah, I mean, obviously I've got maybe a more clumsy way of putting it, but I think on the basis that there's been a significant material change from the setting of the original condition that is no longer relevant or reasonable.
Okay, do you have a seconder for that proposal? Or do we have an alternative proposal? David McKee?
I think we should retain the condition as is at the present moment. There's still over 15 hectares there that will at very least require maintenance of some sort. And what would that be classed as? And there are uses that land could be put to that would cover the agricultural use. And I think on that basis we should retain the agricultural condition.
Okay, Jane?
I will ask our officer about the wording of the agricultural need which justified the approval of the house in the first instance no longer exists. Does that mean if they don't have enough land to keep the 90 cattle, does that then mean that that does not exist? That's the question to me in my mind.
Robert?
The condition, if you read the condition on page 17, it does allow a degree of latitude for need beyond the actual unit itself. Having said that, I fully recognise that in terms of the original planning permission which was granted with the occupancy condition, it was on the basis of farming need identified on that particular unit. It was just this, as I understand it, the standard wording of occupancy conditions at that point in time. So it does loosen it slightly, so it can be employed locally full-time in agriculture, which is a wee bit nebulous, a description in terms of how you define locally. And you've also got the option for forestry as well. The point about dependence is just to obviously cover other parties that live in the house. So it's not expecting everyone in the house to be a full-time agricultural worker. But there is a slight degree of latitude within that condition, but you can see from the applicant's agent's submission that it's primarily on the basis of the need generated by that agricultural unit, 116.7 hectares carrying 90 beef cattle and 40 sheep. And there was justification made on that basis. So when the decision was made to grant permission with the agricultural occupancy condition, that's what was influencing that decision, and that was the basis for the condition.
Jane? Well, we have a proposal from Stephen Thompson and we have a counter proposal from David McKee. There appears to be
Sorry, I find this an incredibly difficult one, actually. But I think I'm going to stick with the recommended decision and go for a refusal. I'm going to second David McKee.
Thanks for that. So at the moment we have a motion from Stephen Thompson, doesn't have a seconder, and an amendment from David McKee, seconded by Jane Maitland. Therefore, I would support Councillor McKee and Maitland, and Stephen Thompson's motion falls. I don't know whether Stephen can record the centre, no clear, but if he can't, will you confirm the decision of the committee, please?
Yes, Chairman, Councillor Thompson can have his dissent recorded, having proposed a motion and failed to secure a seconder, if he wishes. And I can confirm that the local review body have agreed to uphold the decision of the appointed officer and refuse the planning permission as for the removal of condition 2.
Okay, thank you. That's a formal decision of the local review body, and thank you everyone for your attendance today.